even the creators of the technology can't explain how the agency is working, that these AI entities will be acting on their own.
I think Health Canada should have the same type of regime they do for pharmaceuticals.
The courts are struggling with where to apportion liability when an AI system does something incorrect.
Hello, everybody. I am Brody Lawson. Thank you for joining us today for a discussion focused on the intersection of artificial intelligence, medical malpractice, and patient safety. Participants will explore how AI is reshaping healthcare delivery, the legal challenges it presents, the evolving litigation landscape, and strategies for creating robust legal safeguards to protect patients and minimize malpractice risks. We have with us today some great representation from one of the top firms in this space, Gluckstein Lawyers, Charles Gluckstein, Managing Partner, Pinton McGuire, Senior Counsel, and Jan Marin, Senior Associate. Now, let's get started. First, let's delve into AI and its role in healthcare today. How is it transforming patient care, and what are some of the unique legal challenges it introduces? Charles, I'll start with you.
Okay, thank you. Thanks for having us on this program. It's a really exciting topic and an emerging field, obviously. And I always try to just give a framework as to how fast AI is moving. And one thing you can just keep in mind, like Darian Amodi, the CEO of Perplexity, always says this, for every 10 years of human progress, you can think of that being shrunk into 1 year of development. That's where we're at right now. Every time a year goes by, it's like 10 years of what we think research takes. So when we think of what we're talking about today, next year, it's totally different. This is a very important topic because AI has already affected a lot of what doctors are doing in radiology, for example. It's helping people understand scans. It's helping doctors take notes. It's helping nurses triage. It's already involved in so many decisions. And part of the complexity of this is how does that affect standard of care in terms of assessing a doctor's responsibility to the patient or nurse's responsibility, and what kind of disclosure, informed consent is required for patients to be involved in these programs where doctors are using technology, and in terms of going through that and understanding the legal framework. We have two great experts in Pinta and Jan on these topics, so maybe I can sort of dive into some of those topics with them, and Brody, feel free to jump in to the conversation. So maybe Jan, first you can start off and just help us understand where AI, you see it embedded in the different work that hospitals and doctors are using currently.
So for a while now, it's been in place in terms of note-taking and assisting physicians in creating some records, and that's been happening. I've seen it as well in creating referral systems and things of that nature. And I think that there's been lots of hospitals, clinics, individual physicians who are bringing all of these tools into their practice. What I'm seeing that's forefront and coming, which I think actually will be positive for the standard of care in a lot of ways, are some tools where it's going to assist with there being outside review of hospital files, so that there's almost like a legal tickler system where it's going to tell clinicians in the background maybe when there's a miss or something happening. There's also technology that's being used, for example, a technology which will look at skin moles and freckles and things like this and be able to tell clinicians whether they're concerning, and individual patients can use it. Reports can be sent to doctors. So there's some positive things happening. I do have some concerns around the work that's being done in terms of physicians looking up new research and using AI to summarize everything and go around their individual knowledge. So we have concerns about what might happen in terms of physician knowledge and experience and not offloading that to technology. But I think that this cuts both ways. I think there's some amazing opportunities to relieve some of the pressures in the system and the administrative work. But I also do have some concerns about how it's being used. That skincare technology, for example, one of the concerns about that is that depending upon skin tones, for example, it's not as effective. And so are the clinicians realizing limitations of some of the tools they're using? So lots of different ways that we're seeing it. Radiology is another moving target that we're seeing that these tools come into play.
Obviously, it's a powerful data set for a doctor to use that in terms of radiology, obviously well beyond their own knowledge and experience to see millions of scans that are put into the system. But so, Pinta, how would we deal with standard of care questions when doctors do rely on this technology to help diagnose their patients?
Well, if it's equipment being supplied by the hospital, I would think it's primarily going to be a hospital issue. They are typically the purchasers of those very expensive pieces of equipment, and it's going to be their responsibility to maintain them. So, whether it's going to require experts that are going to look at the logs in terms of what updates they have done, what sort of servicing they're doing to ensure that the mechanical AI, which is operating independently, is getting optimal care. So I think it's going to be a hospital liability issue and potentially open the door to larger product liability issues. If there's a design flaw, that could lead to class actions, mass tort type of cases, which again may involve hospitals, but it's largely going to be the manufacturers of these very large pieces of equipment.
I think there's a lot of conversation in AI in general now in different fields about disclosure. When are we disclosing? When are we not? So, from the medical standpoint, how should disclosure be informed and how does it need to evolve? For example, must patients be told that AI is involved and informed of its limitations or know its biases?
I do think informed consent always has to inform how we're looking at these things. So, absolutely. So, I recently had a health assessment and I had to sign a form at the very beginning of it saying that I understood that an AI note taker, and that's such a basic technology, right? That this AI note taker was going to be essentially listening in and assisting the physician in the creation of their note and recording of all the details that we discussed. And even for something like that, it needed to be consented to. And so when we look at, if we go back to the example of the surgical robot, obviously patients are being asked, there's going to be a student in the room. I may have a fellow with me. They may perform parts of your procedure. The same thing is going to be necessary when it comes to this technology, without a doubt in my mind. And failure to inform a patient of the risks and benefits of that technology is going to be a concern. I think probably at the end of the day, if a physician's telling their patient, we have this technology, this robot, it actually improves outcomes from the procedure. It can target this particular very small part of the anatomy with far more precision using CT guidance, MRI imaging, whatever that might be. And the accuracy of the robot is actually, through studies, shown to have better outcomes for patients. At the end of the day, I think most patients are going to say, well, I want to use the technology that my outcome is going to be better with. And a failure to do that is going to be a concern. In terms of outcomes, those are more complicated questions around if a patient's not told, but they probably would have done it. There's no litigation that might result in those cases. But fundamentally, I think patient consent is absolutely important, regardless of what the technology is. If it's used in your care, you need to disclose it.
Where do you see the biggest gap right now between how AI is actually used in hospitals and clinics and the legal frameworks that are supposed to regulate that use?
The regulatory side is so far behind. I mean, we don't even have a AI act right now like the EU does. And although we're modeling it after them. And so when we think of hospitals and, if I go get my eyes checked and they say, well, this is going to be compared with a data set out of the Mayo Clinic or at Harvard study, like, of course, I'm going to say, yeah, sure, take my eye test and test it for glaucoma or whatever it is with your data set. Like there is no regulation that catches up. But as hospitals see efficiencies around the world, they're going to adopt these technologies. So, the leading hospitals, the research hospitals are testing these things at the cutting edge. If it's going to prevent disease, they're doing genetic testing. They're doing all this stuff using large data sets and robotics to improve outcomes. And they're going to do it whether the government says yes or no, and they're going to evolve. And what I think will happen is, there will be litigation that tests the, efficiency or efficacy of these uses of technology. And with that, we will get regulatory legislation that comes out as to the proper use and misuse of this kind of technology. But it's always going to be way behind, especially at the speed things are going right now. That would be my comment, but I'll let Pinta and Jan weigh in on their views.
Yeah, I mean, I agree with that. I think that that's a huge gap, the regulatory issue. I think, as Charles said, a lot of these products are being deployed without a lot of surveillance by the people who should be in charge of keeping the public safe. I think we're going to see governments having to play catch up with what's happening in the market. But I actually think a lot of the physician organizations are probably going to step up, right? Because they need to protect their clinicians from potential exposure as well. So they're going to also be pushing that ball down the road to get some sort of oversight, get some sort of comfort that clinicians are using products that have been tested that are not opening their members up to potential litigation.
Yeah, and I'll just add to that as well. And Pinta referenced this a little bit earlier. I can't help but wonder, about the potential for class actions to be emerging from these technologies because, the understanding about how these products function is often proprietary. And what that can mean is the research and the studies and truly what information has been fed into the programs, because there's this expression garbage in, garbage out, which essentially is how you program the information that the AI is utilizing will inform how well it works. And if the clinicians don't have a fundamental understanding of it, can they fully rely upon it? It's a bit tricky, as a lawyer, we use AI products as well. Do I always understand exactly the data that's inputted in that program? No, I don't. And that's why I double check everything as an individual lawyer who has to make sure that my work product ultimately can be reliable. And so the same thing is going to happen with all of these programs. And I do think there's going to be great encouragement by the hospitals through the clinicians themselves, because there are opportunities here to not only improve care, but to deal with some burnout that we're seeing amongst physicians. And I think that there's huge benefits that many of these products will result in. But I also think some are going to slip through the cracks. They're going to be used, and until they're actually deployed and they're situations where they're not having the outcomes that they intended to have, it's going to result in problems. And, I'm sure we're going to talk about this more as our webinar goes on, but how, as lawyers, we have to wrestle with, is this an issue with a product and the manufacturer? Is this an issue with reliance and how it was deployed? These are very complicated legal issues that we're going to have to face in the coming years.
Jan, that's actually a perfect segue into what I wanted to touch on next, which is about AI-driven errors. And you've sort of spoken to this, but if there is, let's say, a misdiagnosis or a treatment failure caused by AI that's slipping through the cracks, as you've said, how does that intersect with traditional medical malpractice claims? Charles, I'll start with you.
Yeah, I think we are the safeguards, right? So, companies and technology companies would love to move everything to a arbitration system. You see that with Tesla when they develop their new products. If you have a problem with it, they want to test it out on all the roads and test out with everyone and not have any repercussions. That's what these technology companies would love, is just to roll out the technology and just see which works first. And whatever happens, we'll deal with it, but through arbitration, right? They don't want punitive damages or any bad repercussions that stop their progress. But, we are the backstop, right? Lawyers are the ones that are going to hold them to task and make sure that what they roll out is safe. And that, when patient safety is on the line, this is the most critical thing. We don't want the technology to fail. Yes, there are tons of benefits and hopefully millions of people's lives will be saved with the rollout of this eventually. But in the process, we want to make sure it's done properly and safely. So, it's very important that the legal system exists and it can be the check and balance for this interesting emerging technology to make sure it's properly used. So there are difficult questions. In medical malpractice, one of the difficult questions is the science behind what happened. So, someone is sick, they have a terminal illness and they go to the hospital. The doctors can't fix every problem. We know that. And so while there may be mistakes made, which we call a breach of standard of care, the issue is, would it have made a difference? Would it have made a difference because they had stage 4 something that was going to be terminal in the next, 3 months? And so regardless of the mistakes, it wouldn't have changed the outcome. So, I think if I could turn to Pinta first, what are the causation questions that would come up to prove that the technology accelerated or decelerated or changed the outcome of this patient's care? And maybe you can discuss how causation would be applied in a AI misdiagnosis situation.
Well, I think we're already kind of seeing it play out in real time with the rollout of electronic medical records, where there's literally a trail of everything that has happened. And Jan mentioned this earlier. I think clinicians aren't going to be able to solely rely on AI. They can look at AI and look at the suggestions for the possible diagnoses, but ultimately it's their responsibility to exercise judgment. And from a causation perspective, if you can prove that the exercise of that clinician's judgment over whatever AI suggested was the reasonably prudent thing to do, then ultimately it falls to the physician. So you're still going to have to, I think there's always going to be that requirement for at least for the short term, while we get more used to having AI in our life, to have that human check mark at reviewing what AI is suggesting. But I think we're also going to want to look at the underlying data for the AI program. So looking at the audit logs, looking at what were the alternate diagnoses that they suggested. Did the physician have to pick between a number of them? And then the AI then incorporated that physician answer and then came out with something else. So I think, to Jan's point, we're going to have to really understand what goes into these AI models, what information they're using to come up with the diagnosis. Is that underlying language model what they should be drawing on, that AI system? So it's going to get complicated. I think we're going to need different types of experts than we typically have. We're going to need experts who understand these systems really, really well, understand how to drill down, and then explain that in a cohesive and coherent way to a judge or jury. It's going to make it more complicated, but I think we're always up to the challenge. And medicine is an area that has been evolving over my 20 years of practice. What was standard of care and what proved causation 20 years ago has changed. And in fact, causation analysis can change retrospectively. So what you thought caused something 10 years ago, in a case that is now, going through the courts, you can use the available science to establish causation. So I think it's a really exciting time. I think it's a complicated time, but there's obviously going to be experts out there that we as lawyers can draw upon to help us understand these systems and these complicated issues that are going to arise as AI gets more and more involved in taking over a lot of these decision-making that used to be within the clinician's sole exercise of discretion.
Yeah. If I can add to that. So, Charles had asked about causation. I think actually when it comes to AI, causation analysis is going to be the way it is now in many respects, because it's ultimately the outcome and looking at, was it caused by these given events? When I think about AI and how it is going to impact our practice, I really think it's going to make for more complex standard of care analysis primarily. And that's because an example I can come up with, if an AI gets something wrong, even if the clinician used their clinical judgment, relied upon the AI, I think the response we're going to see in a lot of these cases, and the defense is going to be, well, if AI couldn't catch it, how did you expect me as a human mind to catch it? And that's going to be a difficult thing to wrestle with, right? And this is where I do think if clinicians are relying upon the technology, they have to understand the limitations. One of the things that I recently read about was an ECG interpretation by AI. And there are certain patterns on ECG interpretation, which the AI had a lot of trouble with. So sometimes there's noise interference, for example, and a human can see that this is not a normal pattern, but the AI had a lot of trouble saying that this wasn't an accurate reading at all. It interpreted what should have been interpreted as not readable. We need to do this again without the interference. And so there's examples like that if the clinicians don't understand limitations on technology, they're going to be, they're going to have trouble in that respect. And so they do need to understand these things. So in my view, I really think a lot of these really complicated questions are going to be more in the standard of care realm. Causation will always be complicated, but that's looking at the event and the error itself, and did that lead to the outcome, which could be human, could be machine. But the standard of care is going to be complicated. And as Pinta said, I think the biggest challenge for us is going to be finding the right kind of experts who are informed, understand the technology, and hopefully access to data sets. This is something I've been thinking a lot about. Will we have access to the information that we need to prove these cases when it's proprietary? And those questions, they're going to be legal battles, no question about it.
Yeah, and related to this, how should experts frame their opinions on what a reasonably prudent physician would have done? I mean, you touched on it, but how can we think about that more?
I'm happy. I think we've kind of
Yeah.
been talking about this a lot. I think the standard of care, the reasonably prudent physician, is going to have to verify the AI, whatever the AI spits out, against their own clinical judgment. They're going to, as Jan mentioned, have to consider the limitations. Are there biases built into the underlying information that is going into the model that they're relying on? And they're going to have to continue to balance their judgment based on what is being provided by AI. So I think experts are going to have to understand what is out there and understand what physicians are using, what they should be using to opine on whether or not the system that we're looking at in a particular case was used within the standard of care. So I think experts are going to have to expand and understand what AI is making available to other specialists within their field.
It's akin to lawyers using technology. I mean, the end of the day, it's your license that's on that, opinion. And if you're submitting something to the court, it's the lawyer's license, and the doctor's the same thing. If they're the most responsible physician for the patient, it's their license on the line. They've been trained. And if they want to delegate that to, fellows and residents, it's the same thing. They're delegating it to technology. They're still the ones responsible for overseeing it. So if they don't understand it, then they should do their own analysis to make sure that it's in line with their training. The problem is going to be that we are going to get to the point, and we're pretty close to it already, where we can't get experts to explain the technology. Even the creators of the technology can't explain how the agency is working, that these technologies are making their own decisions and they're acting very human, in fact, beyond human, in coming up with responses that we can't explain, teaching themselves new skills. And, it's going to change the landscape of how we define, an individual, because these AI entities will be acting on their own. And the doctor will say, I didn't train this device to do that. It just did it. And that's going to be a challenge. And I think right now where the courts are at is that if it can't be explained and it's not helpful to the court and can't be repeated, it's not admissible. So, in terms of lawyers putting forward evidence that was AI generated, that type of evidence will not be allowed currently.
The change happening so quickly. So, do AI related errors fit comfortably within an existing negligence doctrine, or do you foresee a need for new categories to more accurately capture fault?
We can start with that one. I do think they're going to fall. I mean, negligence, as it's defined, is a pretty broad category. And I do think ultimately, and it goes back to some of the things we've said a few things now. So under negligence, you have to establish a duty of care. That's going to be the clinicians. It's always going to be present in medical negligence. Then secondly, you've got the standard of care breach. This is the complexity we've been talking about. So how did that occur? What happened? What would a reasonable physician or nurse or whatever type of clinician it is have done in the circumstances? And then did that cause injury? So I think it absolutely fits within the framework as we have it. The more complex questions that we're looking at now is, whether there a product liability issue? Are there steps beyond what we look at now, which is far more narrow, and the individual patient experience? When are the times when we go beyond that? When is it an individualized issue? And then that's where, what Charles said, I think is really, really important, which is that ultimately the doctor is responsible for the output, and I think a lot of what we do will be framed by that. And so you cannot just, and Pinta said this earlier too, you can't just blindly rely upon these things. And that's important not only for patient safety, but also for physician knowledge and skills. They can't just blindly rely upon these things without there being, I think, over time, an erosion of knowledge, an erosion of learning. And I think that ultimately all of those things are going to have to be how we frame these cases. And, we already do. We already look at these cases and consider, is there a technology issue when we're talking about any kind of medical product? So that could be something, everyone's heard of class actions involving, certain types of abdominal mesh or other things like that. When technology fails, we do look beyond the healthcare providers, and we will continue to do that. And we are well supported in our firm to have both the medical negligence team as well as class actions. So we're always thinking about these things. And I do think more of that will be happening as this technology increases in use.
Yeah, I echo Jan's thoughts. I think we're going to see a lot more product liability kind of hybrid cases where perhaps you are pursuing both the hospital and the manufacturer of the medical AI device or product that was being used at the time. And you're already kind of seeing it within the social media kind of litigation that's going on in the US and up here, where the end users of the product are suing the creators of this digital product that is using an algorithm that no one really understands, but that is doing harm, right? So I think you're going to see the individual users, the patients who are, who are benefiting or perhaps being harmed by that AI, looking to as a potential additional defendant. And I think that already, as Jan says, fits very nicely within our negligence laws. It's very broad. We have a concept called joint and several liability. So if you can establish a little bit of negligence, but that it was causative of the ultimate outcome, you can sue and recover from multiple defendants.
So this gets us into that topic of accountability with AI-driven healthcare and who is liable. And I just want to add another maybe middle step to what Pinta suggested, which I agree with. And this is what we're seeing in the self-driving car sort of realm, is that individuals that are injured at the harm of a machine-driven car, there was no driver. How do we deal with liability? Does the injured person have to start a products liability case? Because we know how expensive that's going to be. Hiring engineers when they have a broken arm, are they going to spend millions of dollars to pursue that case? And so what they've done in most jurisdictions is the insurance companies are basically stepping up to provide that umbrella coverage the same way they do in a typical motor vehicle case. They're going to insure the vehicle, whether it's driven by a human or not. And so the individual gets their reparations through the insurance company. And if the insurance company feels so driven, they would then have the subrogation claim to pursue product. And I think in healthcare, we could see that middle step because, again, a patient isn't going to be able to hire a lawyer to do a massive product case against a machine. Like, even think we already have machines even before AI, like radiation, all the radiology machines. And right now it's the hospital that you'd pursue for purchasing it and not taking all the steps to, make sure it was safe before implementing it. And maybe include the government in allowing the product to exist in our country without doing proper testing. So I think that case is a little easier for a patient to pursue without having to hire, tens of engineers and wait, a dozen years for that case to go through, because it affects people all over the world. And so you could see hospitals taking over the vicarious responsibility of the robots in their midst and the machines that they're using. So the patient just pursues the hospital. Hospital then can decide if they want to join some massive class action. I think that's kind of a necessary middle step.
And I want to add to that because, this actually is very familiar to another area of law that I practice, which is infertility law, which exists in this similar zone of a lack of regulation. And often my clients are saying to me, I don't want this to happen to somebody else. How can we prevent this? And one of the things that I think there's sort of a bottom-up approach versus top-down when it comes to regulation and why regulations can and do be put in place down the road. And that is, so looking at what Charles just talked about. So in the motor vehicle context, insurance companies, and when it comes to healthcare, whether it's hospitals, doctors, in Canada, it's the CMPA, or insurance companies, because the United States is primarily an insurance-based system, they then step up and say, okay, we're not going to insure you any longer, or your premiums are going to go through the roof if you have to disclose to us what you're relying upon. And all of a sudden, there's a different way to ensure safety, to get more regulations in place. Now you've got these massive, very powerful organizations and companies lobbying governments to say, or, for example, Health Canada, these products might have a new category with Health Canada. So just like pharmaceuticals have to be approved, I could see down the road there being a system where all of a sudden medical technology has to go through an approval process, which really is how it should be done from the beginning, right? Like we should have a system where that's in place, but many, many examples throughout history, whether we're looking at pharmaceuticals, I'm looking at it now in the fertility space, technology goes faster than bureaucracy, which is historically so slow. And so we may see change coming, an urging of different directions. And that's why we all play a part in all of this. And in terms of enacting change and for patient safety, all of these things become very important to get these supports and the rules essentially in place to ensure all of these technology is safe.
So I know one of the important areas is looking at responsibility. And when we're apportioning liability, if we had, a medical robot assisting in a surgical procedure, say a maxillofacial procedure, and it's holding the jaw in place while the procedure's being done, and then there's nerve damage at the end, and we don't know if it's the doctor, the machine, the medication, maybe it was going to happen anyway. So all these issues come up, and then you're in court fighting over it. And do you treat the medical robot that had its own programming as a separate defendant? Do you, when you're naming this case, maybe we can go through how we bring this case to court and how would you analyze it? So I think, Pinta could help us with the idea of, how do we start this claim? How do we research it? How do we put it through? And what's the best approach?
What we do now is we get records. So I think it's just going to mean that we're going to be requesting different types of records at the outset of a case to investigate what went wrong, what AI was being used, and then make requests from potentially Health Canada to, as Jan's point, if they have approved this device, this robot for use in healthcare, what kind of approvals did that go through? So requesting information through freedom of information, perhaps doing your own deep dive on the manufacturer of the robot to determine what issues have been noted in the EU, what has been noted in the US, if there's any issues that have been identified with a particular AI-driven device. And then I think once you have all those records, then you're going to have to look at, okay, well, what did the physician do in this case? Did they do their job of verifying the information or verifying the information that went into the robot before being used to operate on an individual? You'd have to look at the hospital to see what kind of training they employed with that physician and the nurses to make sure that the physicians were properly understanding how to use this device, to make sure that that device was properly maintained by the physician, by the hospital. And then you're obviously going to look at the vendor, the manufacturer of that robot, to determine whether there are any defects. And for all of those issues, you might need one or multiple experts to review all of those issues that you have to establish in a case. I think it's Jan's point. These cases are complicated now. I think they're going to get even more complicated. And as we investigate those cases, we're going to have to figure out, okay, where do we think this lies for the most part? Is it mostly with the physician, the hospital, or the vendor of the AI? Because that might determine how much money you're going to put into the investigation on one piece, or whether you're going to even pursue the vendor if you think that it's going to potentially significantly slow down the case, right? Because right now these cases take a very long time to get through the system. We have a system in Canada where if you are injured through medical negligence, you don't have access to benefits like you do in a car accident case, right? So unless you have private insurance, you are kind of left on your own. So it's really in our clients' interest to move these cases forward as quickly as possible so they can get access to the care that they need. And if you are bringing in, a massive vendor of a product, they are definitely going to slow things down. And do you need to do that? We in Canada.
Yeah, I'm just thinking, do we have to? Jan, if we know that there's enough compensation through the hospital or the doctor, can we not somehow charge them with the responsibility of having this device? We weren't contracted to bring in the device to assist with their, patient efficacy. So why can't we just name them and let them third party the product company? And that way you speed it up. And I mean, I know in motor vehicle cases, if we don't have enough compensation, we would bring in the airbag company or product company because we have policy limits. But, maybe you can comment on in Canada on a medical malpractice case. Maybe we don't name that device in the current state of things.
It's hard to answer some of these questions sort of in a vacuum, because there's certainly going to be cases where the whole defense is that this was entirely product liability. And so the legal risk of not bringing them in is going to be there. And I fully agree with what each of you has just said. And these are going to be the questions we wrestle with in these cases. We won't know the defense. And maybe it's a decision that actually we will put down the road. If that defense is made, well, okay, now we have to amend our claim because this is the first we're learning of information. And there's a discoverability element that comes into the case. Because I entirely agree with what Charles and Pinta have said, that the complexity is increased dramatically by bringing in the product issues. And if we can circumvent that and go directly to the hospital and the doctor to say, well, you relied upon it blindly. And so if it's an issue around, maybe it's a drug interactions issue, if it's an issue around identifying on imaging and a radiologist hasn't done a secondary look, or those cases I can see being fairly specific to, we can get clinician responsibility. But if we're talking about the robot in the surgical context, where the robot is actually performing the surgery with a physician sort of supervising, as it were, that could be more challenging. It really could. And so those cases, it might not be avoidable. And these are questions we're going to be wrestling with. We're going to have to make strategic, informed decisions. This is where, as lawyers, at the end of the day, we'll tell our clients what the risks are. And in the same way clinicians in the medical context have to get consent, we do too. And so we will inform our clients and say, listen, here's the concern. We can wait and not bog down the case essentially with these additional complexities, but here's the risk we run. Or we bring in everybody now, and here's the benefit and the risk of doing that. So, these are the types of things we're going to have to inform our clients about, and these kind of decisions, and what the right path forward is.
I mean, the only other analogy I can think of is that doctors already use tools, whether it's a saw or like we've had a surgical case with a ligature device that was helping with a surgical situation. And we didn't know about all that, right? We didn't know what tools they used. It's not all documented in the initial records. It's part of their regular practice. And then you find out when you say discoverability, we find out, only through the evidence that we hear or, eventually is disclosed in their defense, et cetera. And then we can troubleshoot whether that needs to be added as a party or whether there's a vicarious side to it that we can argue.
So I think that's been a good, way to approach accountability, liability. It's complex, obviously. If we look at recent ongoing changes, maybe even specific cases that are on your radar that might give us some more insight into how the courts are actually addressing the complexities when it comes to AI and healthcare litigation. Have you seen any emerging patterns, be it in Canada or internationally, of how courts are approaching those types of cases when AI is influencing medical decisions?
I can just answer generally because I know the courts are grappling just with AI in general, just, because lawyers are using it to research case law. And there's been lots of publicity about misuse of relying on that data because, some publicly available large language models will come up with answers whether they're accurate or not, because that's what they're told to do. So they're very creative and they come up with fake case names, and some lawyers don't know how. They haven't gone to the extra work of verifying those case sites, and they've made mistakes. And that ends up being a very big problem for the courts, because if they don't do their own research on these cases, then we have a sort of a tampered case history, because that gets reported and those fake cases are now part of our jurisprudence, which is a problem. So that's one side of it, is just the lawyers misusing it. The other side of it is the evidence coming in that's AI generated. So I think that's where the medical side will grapple as well, is that, we're calling experts that rely on AI evidence. So think of an engineer that's coming in to testify about a reconstruction of a car accident, and they've used an AI-driven result to reconstruct the accident, and they're not really sure how it came up with it, but it's favorable for one side, and it's played out as a reconstruction, and it influences a jury or a decision maker judge. And now we have, we don't even know how to verify that. So this is why the rules are going to evolve to make sure that if we are involved in submitting AI generated evidence, that it has to be explainable. It has to be reliable and trustworthy. So I can think of a case, a US case, where an accountant was asked to testify about a will contest and an estate was going, to one party or the other. And the evaluation of the estate was driven through a program that was sort of looking at investments of what this property would be worth over time to then tell the court the present value of that number. And when the accountant was asked to explain how the program he used came up with the number, it came up with a different number. And so he did a live demonstration of it and it didn't work. And the court said, we can't rely on this evidence. That expert was thrown out and the other side's expert was preferred. Pretty serious consequence. Multi-million-dollar estate went to the other side because their expert was thrown out. So you can imagine, and I think Pinta has another example of an expert that could be at risk and how she deals with those experts before they testify. So maybe you can enlighten us on your technique of making sure that this evidence gets in.
Absolutely. I mean, I have been burned by an expert. I think as the technology was being adopted more widely than I think they were disclosing, an expert had used AI for the purposes of pulling out references for a report and had not actually verified the references that were in the report. And the AI, which was drawing on actual medical journal articles, these were real articles, but the AI was misinterpreting what those articles meant, and the clinician or the expert had not verified one. So what the AI said the article said. So I think it's going to be a lot of verification, making sure that physicians are verifying it. Right now, in my instructing letter, I have a very specific piece of information. I'm like, you must disclose if you are using AI and how you're using it, and you must be able to explain it to me. So that is something that I now put into my retainer letters at the outset. And whenever I get a report, and I did this before, but you going through every single reference with a fine-tooth comb so that as a lawyer, I can appreciate, yes, this is correct. Whatever proposition they are relying on for this journal article, I can verify it. I think we as lawyers are going to have to deal with it. I think the courts are struggling with where to apportion liability when an AI system does something incorrect. But there was actually a case out of BC, I think last year, a small claims court case where it was Air Canada, and a Air Canada user had relied on the AI bot for information. And I think the user was trying to get home for a funeral, and the AI bot gave incorrect information. And the court found that Air Canada ultimately was responsible, notwithstanding the fact that Air Canada's defense was it wasn't us, it was our AI bot. So I think the courts are going to look to the vendors, to the companies that are relying on these AI services to improve their company profile and improve the services that they're providing to customers, but ultimately will hold them responsible.
I'm going to add as well to that. So the courts are behind the scenes actually very much grappling with these issues. And in Ontario, for example, there's a committee that's been struck to actually look at incorporating some new rules on evidence that has touched AI in any way. And that can be, so we've already talked about the expert side of things, but that could actually also end up dealing with the records themselves. And so one of the things, and so I'm in a working group with the Trial Lawyers Association looking at the proposed rules. And one of the concerns that we had was the court, and again, just like any of us really, when looking at the requirements that they wanted to put in place, doesn't really have a full understanding of what does data set mean. And so one of the proposed rules was that there has to be full disclosure of any data set if your records have anything to do with AI. And one of our concerns was, hospitals use AI in dictation software. This is really common. It's a very basic technology, really. And the doctors will dictate their surgical note, a consultation note. The AI software puts it into the format to be in an actual note and publishes it to the EMR, the electronic medical record. And one of our concerns was the practicalities of that, right? So are we really going to ask for data sets behind technology that's been used in the creation of records that is fundamentally not implicated in the facts of the case, because we think that might go too far, or at least that's something that should be of concern, because we don't want to also overcomplicate. And I love Pinta's example about Air Canada, that the courts and these kind of decisions, there's not been a lot. And I know, Brody, one of your questions is, how are the courts dealing with this? We're on the forefront of that. We don't know yet. And so having that case where Air Canada is ultimately responsible for the tool they use as a business, that's great for us. Those are the decisions which are going to really help us, because ultimately you relied upon it. It didn't work how it was supposed to work, and there was a consequence. And so if that's linear, if we can just keep that linear to the company, clinician, whomever, relying upon the technology, that simplifies everything. Does it stay that way? We'll see. I mean, defenses are going to get more robust in this space, for no question. They're going to try out different approaches, see what works, and we'll have to adapt.
So I'm on that AI subcommittee that does those rules. And I think it's a little more broad than asking for the proprietary information of what comes up with that software. But again, it goes back to, is this AI generated evidence helpful to the court if it's going to be admitted for its purpose? So, is it relevant? Is it material? Is it necessary? Do you need it? Same kind of thing as admitting an expert. Is there anything else that would exclude it? Is it valid and reliable, tested? Is it peer reviewed? Like that kind of stuff. So I think where you'll have trouble is if it is an in-house program. So a hospital develops its own system and it's not working well, like it's not reliable, that's going to be bad for the hospital, right? I mean, it'd be great if they can say, oh, it's this off-the-shelf system, from a Silicon Valley company that 100 other hospitals are using. Then that's going to be something that is probably wider reviewed, et cetera, et cetera. So it's not that we have to delve in and provide the data, the LLMs, for all of this stuff we're relying on. Nobody can get access to that. But will it be reliable if we asked it the same question again? And I don't see it coming up in the context of proving a clinical's chart, like a patient's chart. But if you are calling an expert that's relying on AI-generated research or using some sophisticated program to come up with their opinion, that's the issue the court is grappling with. How do we test that? How do we make sure that's reliable? It's not just a calculator anymore. It's not just an Excel spreadsheet anymore. It's got its own mind of creating this program, and that's going to be an issue that we want to make sure a human is part of this decision process, and it's not well out of our scope of understanding.
Yeah, and to your point, Charles, I actually do think we're going to have to really understand when clinicians are using AI, and to use Jan's example for that dictation services, when those services get more robust, perhaps that surgeon, instead of describing what they actually did in the surgery, prompts the AI to say, what are the typical steps that you do in the surgery? And then the AI spits out what they typically do, not what the surgeon actually did. So I think we're going to have to understand, okay, you dictated this note, but what does that actually mean? Was it all you that authored it, or, was the prompt that resulted in the, what is described as reasonable? So I think, as we've all talked about, it's going to get far more complicated, but thinking about how physicians are going to be using it and how they're going to use it to both improve their practice, but also to protect themselves from liability, and relying on AI to verify what they're doing, but also to suggest what they should have done in the circumstances. So,
well, just like policing, they should be wearing cameras, right? I mean, there should be cameras in the surgical suite that are available to the patient if the patient is complaining about the service, not for any other purpose. But even if there's going to be robots in the surgical suite, then those robots should have cameras as well. So, I mean, I would expect that's a pretty easy solution. I don't know why it hasn't been implemented.
You hit the nail on the head, though. In fact, you cannot get your videos from surgery. Clinicians went up in arms when there was a suggestion that information belonged to the patient. They don't want the recording of what they actually did in the hands of the patient. But, to your point, Charles, I think it should change. It is personal health information. And it's going to be really interesting because there are so many privacy laws around personal health information. If personal health information is being used to train these systems, are they protecting, or are they following the privacy laws that are in place? So there's potential privacy breach issues. And
We've already spoken a little bit here about sort of the legal frameworks that are in place to help protect against AI-related malpractice. I'd love to hear from each of you as we wrap up here. Just what would you say are some sort of baseline regulatory safeguards that you consider essential before AI is widely deployed, or really anything else about those safeguards? I'll start with you, Charles.
Yeah, I think that piece on vicarious liability is going to be very important as a stopgap, because there's no question in the next year, we're going to see a lot more use of robotics and AI data sets to drive improvements in healthcare. And, the only thing that would go alongside is to ensure that, for patient safety, they don't have to invest in these large class actions. In fact, they could just proceed against hospitals and doctors as they always would, and the vicarious liability should be interpreted very broadly to protect their safety.
Yeah, I think we're going to have to make sure that the contracts with these hospitals provide some transparency as to what the indemnification relationship is between the vendor of the equipment and the hospital. So I think we're going to have to understand those contracts. I think from a regulatory perspective, I think the government has to ban indemnity for those manufacturers of the technology. I think they should be held responsible where the circumstances warrant it. And also from a regulatory perspective, I would love to see, a registry of what is actually being used and how it's been tested, what complaints have been made, those sorts of things. So I think there's a lot of room for the government to provide some safeguards for patient safety.
Jan, you liked that, but you've got the final word.
I did like that, and that I was going to approach it from that regulatory perspective. So number one, I think Health Canada should have the same type of regime they do for pharmaceuticals, and that would include having to apply before your technology is licensed to be in use in healthcare in Canada. Essential. And that would include a mandatory reporting, just like for vaccinations, for example. If there's any adverse consequence, it has to be reported. It has to be reported both to Health Canada as well as back to the technology manufacturer. There's no way that they're going to be able to improve if they don't know what's actually happening. And then second to that, in Ontario, for example, the College of Physicians has all kinds of guidelines and policies, all different kinds of things, use of controlled substances, boundary violations. They have hundreds of different guidelines. They need to have one on technology in healthcare and provide their members with guidance. So for example, if you're going to be using this in practice, patient consent is key. Also, ultimately you are responsible for the output of this product. You need to verify it. This kind of thing, that we need to put these things in place in order to ensure patient safety.
Charles, Pinta, and Jan, thank you so much for your time and sharing your insights with us today. This is a very complex and evolving area, and I am sure there is going to be much more discussion to come. So thank you.
Thank you.
Thank you.